the applicant's case waxes and wanes depending on what they think would be of assistance to the relief. Sometimes their case is a privacy case. Sometimes their case is a defamation case. Let me start with the privacy case. If their case is a privacy case, you have private documents, you may not use them. Well, I've already explained why the privacy case doesn't get out of those starting blocks. So that case is plainly bad. But even if the privacy case were good at that level, it's clear that private documents is not a general basis to interdict publication. On the contrary, the Financial Mail versus Sage makes clear that the public interest is critically important. And I'll come back to how you balance in a moment. So if their case is privacy, that's not they can't even start. But even if they could start, they can't end, because the point is public interest matters a great deal. If their case is defamation, they've got an even greater problem, because their case on defamation would have to be, these are the passages which are defamatory. These passages are defamatory of the applicants, not somebody else, the applicants. That's so. 1, they're defamatory. 2, they're defamatory of the applicants. 3, they are unlawfully defamatory of the applicants. In other words, they're false or whatever basis. They don't even get out of the starting blocks. They do not identify the passages. The most that they do is they say that the articles are one-sided. With respect, my lord, one-sided might be all sorts of things, but it's not an unlawful defamation. They then say, well, we needed to be heard. We had to have a right to respond, and you only offered us excerpts of the document. Our learned friend, Mr. Stratton, compared it to a witness who doesn't get given the document. Lord, the appropriate analogy is different. The appropriate analogy is that you say to the witness, I know you've got a document in your possession. I'm going to give you part of that document. Could you comment on that? That's the analogy. They've got the documents on their own version. But in any event, the right to reply is not that kind of requirement. We've demonstrated it in our heads on the counter application. It is not a requirement of Pagoshi invariably. It's not even this duty of make available everything you've got is not even part of our admin law. And we've given you the authorities for that. So the point with respect is just without any merit. And then they say, well, we rely on the press council and the press code, and our learned friend Mr. Maleka pours scorn on the notion that only the press council can enforce that. But he doesn't deal with the judgment we've put up, which is your lordship's judgment, the judgment of your lordship's brother in Matojani J, recycling and economic development versus MNET, which we've cited in our heads. So they've got all sorts of problems with the cause of action. But let me take a step back and let me assume that the cause of action is good in one or more of those respects. They still haven't come home under the requirement for a prior restraint enunciated in MIDI television and repeatedly endorsed by our courts, including in print media. Could I just spend, and I'm almost done, could I spend 1 moment on what MIDI television was about? Because they say this is just a process order. Well, let me tell you what happened in MIDI television. MIDI television was a case in which ETV wanted to broadcast a program which contained interviews with witnesses who were going to be testifying in a criminal trial. Somewhat audacious, one might say. So ETV wanted to run this story about the Baby Jordan case, and they wanted to include interviews with the very people who'd witnessed the murder and who would become witnesses in the criminal trial. And the DPP, perhaps understandably, was outraged and went off to court and said, they wrote to ETV and they said, we want to see a copy of this documentary in advance. Because when we see it in advance, we'll know whether there's a problem. And ETV said, we don't give out our documentaries in advance. This is not the UK in 1981. We don't give out our documentaries in advance. Forget it. And so the DPP goes off to court and gets an order interdicting ETV from broadcasting the documentary, not indefinitely, only until they've given the DPP an advance screening. That's what the High Court held. The SCA in trenchant terms held that that judgment was untenable. It said that you could not require the media to give an advance citing to someone. But more importantly, that even if there was some fundamental issue like the administration of justice at issue, that did not outweigh the public interest in the unfiltered and unfettered flow of news. And it said again and again and again, Judge Nugent saying, the remedy is after the fact. In all but the most extraordinary cases, the remedy is after the fact. Why? Because we don't engage in prior restraints. and exactly the same principle was endorsed in print media, the Con Court expressly endorsed it, saying that you don't give prior restraints except in the most extraordinary circumstances. And Lord, let me assume against myself that there is somehow a cause of action on this leg, either privacy or defamation, or not given a proper right to reply. Nothing that is said makes this case so exceptional that it takes it out of the ETV or the MIDI television case. Nothing. And on that basis alone, the order cannot stand. If they had gone to court and said, if they hadn't sought the prayer about the return of the documents and they just sought an interdict, they would have been laughed out of court. But instead, because they bring in this return of the documents and buttress it and add this, somehow it becomes different. With respect, this case is a non-starter on this leg too.